जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम सृष्टि सुंदर दीप दिल्ली विश्वविद्यालय में हम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम सकल वसुधा निज कुटुंब की भावना संस्कृति सनातन आधुनिक शिक्षा पुरातन ज्ञान धाराओं का संगम देश की स्वाधीनता हित भूमिका शतकोटि वंदन निष्ठाधिक सत्यम के मंगल भावों का समागम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम भव्य महाविद्यालयों के परिसरों से चिर सुशोभित श्रेष्ठ गुरुजन कर रहे मित छात्र और छात्राएं दीक्षित सदचरित्राचार पावन साधना संकल्प संयम नवल वैश्विक चेतना नवक्रांति संस्कारों का उद्गम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम श्रेष्ठ सुंदर देव दिल्ली विश्वविद्यालय में हम जयति जय जय जयति जय जय ज्ञान का आलोक अनुपम ज्ञान का आलोक अनुपम ज्ञान का आलोक अनुपम
I request all the distinguished guests to please light the lamp and Sagar the Music Society to please invoke the Saraswati Vandana.
हम सवारिणी ज्ञानदायिनी हम सवारिणी ज्ञानदायिनी ज्ञान का भंडारिणी शारदे वरदान दे ज्ञान का भंडारिणी शारदे वरदान दे हम सवारिणी ज्ञानदायिनी हम सवारिणी ज्ञानदायिनी ज्योति दात्री हो विधात्री ज्योति दात्री हो विधात्री ज्योति का उपहार दे शारदे वरदान दे ज्योति का उपहार दे शारदे वरदान दे हम सवारिणी ज्ञानदायिनी हम सवारिणी ज्ञानदायिनी विश्व के अंधेरे घट में
I now request our principal, Professor Gyanatosh Kumar Jha, to kindly felicitate our speaker for today, Professor Vageshwari Deswal. I also request sir to please give the welcome address.
Thank you, Dr. Anusuti. Honorable Professor Vageshwari Deswal, Professor Faculty of Law, and today's guest speaker for this awareness program, Professor Vinita Tuli, Coordinator IPSC, participants, faculty members from various colleges, students from various colleges. It is a great pleasure and honor for me to welcome you all in this awareness program regarding new criminal laws in our college. And I feel honored that our Honorable visionary and dynamic Vice Chancellor Professor Yogesh Singh Ji has taken this initiative to organize this kind of awareness program in various parts of Delhi. And university has made 3 nodal colleges for various areas, and our college is nodal college for the South Campus colleges. It's an honor for me and my team members, IQSC coordinator and other faculty members and students are overwhelmed to welcome you all in this August gathering for this program. As Dr. Anusuti has informed you that our Honorable Dean of Colleges, Professor Balram Pani, is on the way. He is somewhere in traffic jam because of bad weather, and he can reach any time. So it's a pleasure for me and honor for me welcoming him also, because he is the man who is behind all the appointments and promotion made in the Delhi University. He made all these appointments and promotions possible for all of us, and deadlock was broken, and I think now everyone who are working in the Delhi University, almost 90% are permanent position, they feel happy. So these 3 criminal laws, Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023, and Bharatiya Sakshya Adhiniyam 23, are going to replace the existing British era colonial laws, namely Indian Penal Code 1860 and others. So expert is here, and he will explain you what are those laws and how our government and Honorable Prime Minister has changed this law, passing the bill in the Parliament. So it is a pleasure for me also that I would like to know each and every aspects of the new law and old law also. So I am grateful to you, Professor Madam, that you have given your valuable time for all of us. Thank you so much. Thank you.
Sir doesn't appreciate this from us. Apologies, sir, but on behalf of the organizing team, we have a small planter to welcome you as well, sir. Meeta ma'am, please do us the honor. Before ma'am enlightens all of us, a brief description about ma'am is much needed. Professor Deswal, Professor Dr. Deswal, is a distinguished law professor at the University of Delhi. She is renowned for her expertise in criminal law and gender justice. Her illustrious career spans academia, authorship, feminism, journalism, and activism. She is a prolific researcher and has authored 8 books and numerous research articles in prominent law journals. She has undertaken research projects with the National Commission for Women, National Human Rights Commission, National Human Rights Commission, my apologies, and the Indian Council of Social Science and Research. She also has a blog called Legally Speaking, which is published by the Times of India, and this blog reflects her commitment to the legal discourse and has been very important in shaping the various debates in the public domain. Dr. Deswal serves as a resource person at various judicial academies and administrative training institutes as well. She has contributed to the legal education and reform initiatives in the country. Her insights on legal matters are frequently sought by national television channels like Doordarshan, Sansad TV for legal discussions. Currently engaged with the Department of Legal Affairs, Ministry of Law and Justice, Professor Deswal is pivotal in raising awareness about the new criminal laws. She is also credited with pioneering textbooks on these very legislations. She's made a significant contribution to the legal education and practice of the country and continues to do so today. Her dedication to advancing justice and equality underscores her impactful contributions to academic scholarship and societal welfare. Her work continues to enrich legal dialogue and inspire meaningful societal engagement. Without further ado, ma'am, please.
Good morning to all of you, and thank you for giving me this opportunity to interact with you all on these new criminal laws, and also a big thank you for braving the weather and the bad traffic to still make it to attend this program. So today we'll talk about the new criminal laws, and when we talk about the new criminal laws, first of all we need to understand what is the law relating to crimes in our country. When we talk about criminal law, there are 3 main enactments that we need to know. One is the substantive law, which was earlier the Indian Penal Code of 1860. Now, what is the substantive law? The one that lays down what is the substance of a crime. That is, what are the essential ingredients of a crime. For that, we had the Indian Penal Code, which also prescribed what is acceptable conduct, what is something that you are not supposed to do, and what is the punishment in case you do that thing. In addition to that, the substantive law also lays down conditions that guarantee exemption from criminal liability. So that is the substantive law. So in addition to the substantive law, there is a procedural law which lays down the procedure for apprehending criminals, how they are to be tried, how they are to be punished, whether they are to be granted any sort of a bail and all these things. That is covered under the procedural law, which was earlier the CRPC. In addition to these two main laws, we have another law, which is law relating to evidence. That is the codified law that lays down rules of taking evidence. But this is a law which is common to both the civil as well as the criminal domain. So when we talk about amending one of these laws, we cannot do so unless the other two are amended too. Because substantive law, which was earlier the IPC, is the main law. CRPC serves to facilitate how those who commit any crime, commit any act which has been declared to be a crime under the IPC, how they are to be punished. So while IPC lays down what is to be proved, Evidence Act tells us how it is to be proved. So that is why these three laws, they are always to be read together. None of these can be functional in isolation. So that is why when we talk about the new criminal laws, we are talking about all the three old laws now being overhauled to give us the new three criminal laws. First of all, we'll talk about decoding the titles. Now we have Bharatiya Nyaya Sanhita 2023. This has replaced the old Indian Penal Code, which was enacted by our colonial masters way back in the year 1860. See, in life, in society, in nature, the only constant is change. And law, it serves the needs of the society. So as the society is changing, law needs to keep itself updated with the changing needs of society. And a law which was enacted in 1860, see, since 1860 to 2023, we've come a long way. How can such an old law be sufficient to meet the rising challenges of society? So that is why what was required was to make laws that were contemporary, which employed a progressive language and which were futuristic. So that is why this is an attempt at also decolonizing the laws, because those were the laws that were enacted by our colonial masters. And that is why when they made a law, the objective was to keep their subjects in control, and the emphasis was on punishment, that anyone who dared to transgress the norms that were laid down by them, then the focus would be on punishment, punishing those persons. And that is what is implicit in the title also. It says Indian Penal Code. Now what the law reflects is a change in the perspective from penalty towards justice. Because this is a law which has been enacted by our democratically elected leaders for our own people. So the focus has to be on serving justice. And justice, see, when we talk about the criminal justice system, punishment to an accused person does not necessarily translate into justice for the victim. See, the trial, it is always initiated by the prosecution. The accused is punished. What does the victim get? The victim is usually isolated in the criminal justice system. If required, we sometimes call over the victim to testify as a witness, but that is it. We don't ask the witness whether the accused is to be granted bail. We don't even ask the victim whether against the accused the state can drop the charges unilaterally. That is what the state does. The state withdraws from prosecution when the state feels so. So what does the victim get? Restitution is a feature of civil law. In civil law, we grant compensation, but in criminal law, what does the victim get? So that is why this is a law with emphasis on justice, justice to the victim, justice also to the accused. Sometimes a person who is wrongly accused of a crime is also a victim of the system. So for such people also we need justice. So what about a first-time offender, a petty criminal? IPC prescribes only the punishment. There is no other way out. At least now we have introduced a concept of restorative justice in the form of community service as a kind of punishment, so that we can have a lenient approach towards first-time offenders, those who are capable of being reformed, and when there is a possibility of, yes, the person, he can be, by giving a non-custodial sentence also, the person can be asked to do something for the welfare of the community, and this is an attempt at re-socializing an accused person. So we are talking about now justice to all the stakeholders, whether it is the accused, whether it is the victim, and also the society at large. Then coming to Bharatiya Nagarik Suraksha Sanhita. a code that is committed towards the protection of security and safety of its people. That is Bharatiya Nagarik Suraksha Sanhita. Earlier this was the Criminal Procedure Code of 1973. See, when we say that this is an attempt at decolonization, see, 1973 was not enacted. In 1973, we did not have our colonial rulers here. See what happened, that IPC was enacted in 1860. The very next year, a CRPC was enacted. 1861. Again in 1862, there was another CRPC. Why there were two procedural laws? Because one was operational in the presidencies, other was in the provinces. Thereafter, we consolidated the procedural laws in 1898, and after we got our independence, we realized that we did not need a merely objective procedural law, which was just applying the law blindly. We also needed to constitutionalize our procedural provisions. And that was when we brought in the CRPC of 1973 to suit the ethos of our people and suit the needs of an independent India. That is why it was replaced in 1973. But CRPC we got in the year 1973. Have you heard about the Bhagalpur blinding case? A movie was also based on that, Ganga Jal. Okay. Now that was the case. See, 5 years after we got the new CRPC, there was a case in which 31 under trials and convicts, they were blinded in the prisons. How? Police officers, they poured acid in their eyes. No cognizance was taken of that. The magistrate did not do anything in this regard. The media brought attention towards this. Those people, after a year, they were brought to Delhi, wherein the doctors said that the damage had been done beyond repair and their eyesight could not be restored now. Now the question was regarding the accountability of why these people, they have had to suffer all this. See, the thing is, the police has the right to arrest, the police has the right to investigate, trial has to be conducted, punishment is to be given by the judiciary. And that too as what has been laid down in the law. How can the police officers, how can they indulge in such acts of torture? So what was being done? What about the rights of arrested persons, rights of accused persons? Even when a person is convicted and sent to the prisons, still his human rights don't elude him. He still has the basic human rights which our constitution guarantees to him. So all that was not available in the new CRPC also. Then what about the victim's rights? Any compensation for the victim? What about bargaining? What about witnesses? We say that witnesses are the eyes and ears of criminal justice system. But we know that witnesses seldom they come forward to testify because they are scared. We don't have any mechanism in place which will safeguard them once they have testified against the accused persons. So all that was still missing. So that is why now when we decided to amend our IPC, CRPC also had to be amended because since 1973, what was happening was that jurisprudence was developing definitely regarding accused persons' rights and all. We had landmark judicial pronouncements. Some of them, they were incorporated in the law also, but what we had was a haphazard mix. IPC we got in 1860 till 2023, we had amended it 76 times. We had a total of 511 sections, so whenever we would feel that we need to insert a provision, we would insert it as A, B, C, D, A, B, A, C, A, D. So what we had was a haphazard mix, it was not properly structured, and what was required was that old redundant provisions, they had to be effaced from the statutes. New kinds of crimes, they had to be recognized and brought into the statute. So all this had to be done. And that is why we replaced the IPC with Bharatiya Nyaya Sanhita, CRPC with Bharatiya Nagarik Suraksha Sanhita, and the Indian Evidence Act, the literal translation is Bharatiya Sakshya Adhiniyam. So what are the changes? Just at a glance, a quick glance. In Bharatiya Nyaya Sanhita, we have added a total of 20 new offences. Jail term or fine, it has been increased in 116 crimes. Mandatory minimum punishment has been prescribed in 23 crimes. Community service has been prescribed as a form of punishment in 6 kinds of crimes. Then in Bharatiya Nagarik Suraksha Sanhita, new sections, subsections and clauses that have been added are 92 in number. Total modified provisions are 117, 14 sections have been deleted. 35 provisions require the employing of audio, video, electronic means to establish the guilt of the accused person. Timelines have been specified in 35 places. See, it was very much necessary because we all know that justice delayed is justice denied. You must have all seen the movie Damini. Even if you've not seen it, you must all be remembering the dialogue. कोर्ट में क्या मिलता है? तारीख पे तारीख. Now that is something which has to be curbed. Now, see, people, they are scared of going to the courts because there are unnecessary adjournments. Now, what the new law provides is specified timelines. Once the FIR has been registered, investigation has to be completed in a time-bound manner. Thereafter, the trial has to be completed in a time-bound manner. Once the trial is completed, the judge, he cannot sit on the order or the judgment. He has to necessarily pronounce it within a specified time period. So this is an attempt at streamlining the procedure so as to curb unnecessary delays. So that is why timelines, they have been specified at 35 places in the BNSS. Then coming to the Bharatiya Sakshya Adhiniyam, new sections, subsections, explanations and provisos that have been added are 15. There have been 24 modifications and 10 sections or explanations, they have been deleted and all. Now let us talk about the historical background, tracing the evolution, some of it we have already discussed. But the first Indian Law Commission was set up in 1834 under the leadership of Lord Macaulay. And that is why IPC is also many times referred to as Macaulay's Code, because he was the chairperson of the first Law Commission. After that, there was this Lex Loci report, 1840, which sowed the seeds of division in our society, because that was the report which said that we need to consolidate the law relating to criminal matters, but relating to personal matters, let these Indians be governed by their separate religious laws. Let there be a separate law for Hindus, let there be a separate law for Muslims, because that was something that aligned with their policy of divide and rule. So at a time when we were codifying, they were codifying our laws, they did so only in the criminal law domain, but our personal matters, they left for us to sort out amongst ourselves and keep fighting over that for the longest time. Then the second Law Commission, it was set up in 1845, and finally after 1857, the revolt of 1857, when the Britishers realized that India has got a lot of potential, so what happened? The East India Company's rule, it was discontinued after that, and in place the British Crown, it established its domain over us, and then they codified our criminal law, which is the Indian Penal Code 1860, that we got. Then we got the CRPC, then CRPC. Then in 1973, our Law Commission in independent India, it had recommended that we need to overhaul our criminal laws. But then amending the IPC was too big a deal. And moreover, see, some things we have to admit, that although the objective of Britishers was to crush our spirit, the objective was to punish us, to put us in line, but some of the provisions that they put, the jurisprudence that they have created in respect of certain crimes, that is very good. And that is why even now when we have replaced IPC with PNS, almost 70% of the provisions, they have been retained in toto. So at that time what was realized, that maybe let us just amend our CRPC and let us continue with the old IPC with some amendments. So that was why at that time, IPC and Evidence Act were not amended. It was only CRPC that was overhauled and replaced by this 1973 law. So what is the objective behind these three new laws? First is decolonization, because it was enacted by our imperial masters. It's been so long since we got our independence. Why did we have to wait for so long also to have our own laws? We should have the confidence that this is a law which has been enacted by our people for us, and it is our interest that would be taken care of in this law. Then we had to make the laws contemporary. We needed to use progressive language. We need to align our laws with new progressive enactments. See, we have the Child Marriage Prohibition Act. The age of marriage is 18 for girls, 21 for boys. Then we have the POCSO. As per the POCSO, age of consent for both boys as well as girls. POCSO is Protection of Children Against Sexual Offences Act. So in that, the age of consent that has been prescribed is 18 years. In IPC earlier, the age of consent was 16 years. It was after the Nirbhaya incident that we raised it to 18 years in 2030. But when it comes to consent of a married woman, okay, so there again we had kept it at 15 years. On one hand, we say that a marriage of minor is not permitted because we have the Child Marriage Prohibition Act. On the other hand, what we say, under the Indian Penal Code, which is the main law, that if a girl gets married beyond 15 years of age, her husband has the right to establish conjugal relations with her. So how do you reconcile these kind of discrepancies in the law? So what we needed to do was, we needed to bring the law, the age of marital consent to a uniform 18, and that was also in accordance with the judgment which was passed by the Supreme Court of India in Independent Thought versus Union of India, in which they said that any kind of distinction between a married woman and an unmarried woman, when we talk about age of consent, that is arbitrary and that is discriminatory and that needs to be struck down. So we had to align our new laws with progressive legislations and also in tune with the times according to what the judgments have been delivered by our courts. So this is just one example, we'll discuss many more. So from IPC to BNS, we have tried to make certain crimes gender neutral. So the first step when we talk about gender neutrality is, see what we have done, we have defined who is a child. Till date, IPC did not define who is a child. At places you would come across the term minor and then the interpretation of that term was minor was different at different places. Like if we talk about kidnapping, a girl could be kidnapped till the time she attained 18 years of age. For a boy, this age was 16. Beyond 16, he could not be kidnapped. See, as per the law, many times you must have read in the newspapers, a 50-year-old man kidnapped. An old person cannot be kidnapped unless the person is indisposed or is a person suffering from unsoundness of mind, because as per the law, who can be kidnapped is only a minor. Because the title of the offence, as is given under the law, is kidnapping from lawful guardianship. So who is under the care and custody of a guardian is only a minor. Adults, they can be abducted. Okay. And under the law, what was the age? Now for boys it was 16, for girls it was 18. So that is how it was different. Now what the law says, it says child is any person below the age of 18 years. Now when we talk about any person, so it is not only restricted to boys and girls, we are also talking about trans children. Because till date, we did not recognize or acknowledge transgenders as human beings under the IPC. But we got the Transgender Persons Right to Identity Act in 2019. Now they have been acknowledged as equal human beings. So now what the law says is, when we talk about the definition of the pronoun he, and it's like whatever, it would include he, she and all other persons. So now we are talking about a very inclusive approach in which we are also talking about trans persons. And especially when we talk about trans children, see earlier when we talked about trafficking and all related provisions, we were talking only about boys and girls. Whereas we all know that trans children, they are extremely vulnerable to being trafficked. Because see, during their teens, when they hit puberty, that is the time when they realize that they don't fall within the established binary. That is the time when they start going into depression or start withdrawing from the people around them. The peer group shuns them. Many times the family members, they beat them. They subject them to corrective rape. Sometimes they are subjected to hormonal therapies. And God knows what all is subjected, the child is subjected to. Many times kids, they run away from the home. Sometimes they are thrown out of their houses. Now such children, they are easy targets for predators who might be their own family members, relatives, and traffickers. So we need to protect those vulnerable children, and that is what has been done now when we are talking about making this term gender neutral. See, there's a very slight change in the definition, but what happens? It has a lot of effect on the remaining provisions. Like if I give you the example of the term movable property. Earlier, movable property was only property which was corporeal. Now what happened in 1860 when we got the law, at that time it was okay that it is only movable property that can be the subject matter of theft. But after some time it was realized that there were so many instances of theft of electricity. But going by the definition of movable property, since electricity is incorporeal, intangible, it cannot be the subject matter of theft. So what we had to do, we had to enact a separate electricity act to deal with instances of theft of electricity. Now, in the 21st century, when we are all grappling with the issues of data theft, intellectual property theft, how can we allow such a definition to continue? And that is when Information Technology Act is already providing us redress for that. And the main law is silent about that. So now what has been done? They have just made a slight change in the definition of movable property, and it says movable property includes property of every description. So now every description, of course, the other conditions are there, that it should not be attached to earth and all these things. That is there, but then we talk about property of every description. It could be corporeal, incorporeal, tangible, intangible. So now all cases of identity theft, data theft, that can all be taken care of by the new BNS. That is how it has been working. Then talking about bringing in gender neutrality in crimes, how many of you know that sexual harassment of men is a punishable crime in our country? See, most of the people, they don't know. We know about the POSH law. Now, POSH law is a gender-specific law which protects only women, and the perpetrator can be both a man as well as a woman. But at the time, the year when we got this POSH law, at the same time in April, we also had certain amendments in our IPC in the wake of the Nirbhaya incident, and at that time, sexual harassment was also introduced as a crime. And that sexual harassment, it is partially gender neutral in the sense that the perpetrator of sexual harassment can only be a man. But the victim of sexual harassment can be both a man as well as a woman. So our law, it acknowledged that even men can be subjected to sexual harassment. Now what have we done? We have tried to bring in a partial gender neutrality in two more provisions. One is, we are talking here about voyeurism, and one we are talking about disrobing. See, disrobing is extremely derogatory to womanhood. We often hear instances where a woman, she is disrobed, she is paraded naked, she is declared as a witch and all these things. So all this is done to humiliate, to embarrass that woman, to punish her for whatever they feel that maybe she has transgressed some societal norms or anything. So mobs, they usually indulge in such activities. Disrobing is considered to be such a serious crime that even abetment of disrobing is punishable under the law. That is, even if anybody instigates, abets or encourages the commission of a crime. Now, as per the law, only a man could be held guilty of disrobing, as per the IPC. But we all know that when there is a mob that congregates, there are men, women, trans people, there are so many people involved, and usually people, they draw strength from numbers. Something which they could not have done on their own, but when they see others also involved in that activity with them, so they do things which they would not have ordinarily dared to do. So now what have we done? Disrobing, it has been made partially gender neutral in the sense that the perpetrator can be any person. Whoever. We have replaced the term man with whoever, but the victim can only be a woman. Similarly, coming to instances of voyeurism, perpetrator can be any person. It can be a man, woman, trans person, it can be anyone. Victim can only be a woman. And then another significant change relating to gender neutrality is when we talk about harboring. See, harboring an offender is also a crime. One who commits a crime, you provide shelter to that person. You are an equal criminal in that respect. But there is an exception under this, that if the harbor is provided by the wife of the accused person, the wife would not be held guilty for harboring. So earlier only wives could provide harbor because it was presumed that it is only men who are criminals. Okay. Thereafter, when we talked about deserter, so harbor of deserter, only a wife would have harbored her deserting husband because it was only men who were serving in the defense forces. But now women are also contributing towards the safety and security of their nation. So now even women can be deserters. And if their husband gives them some sort of a support or harbors them, the exception which was applicable to the wife would now be applicable to the husband also. So now the term wife has been replaced by the term spouse. So that is another step towards gender neutrality. So these are certain very minor changes but which have a great impact on the overall understanding of the law. Then we have introduced new crimes to deal with changing needs of society. Like, see, we have introduced section 95, which talks about employing, engaging or using a child in the commission of a crime. Now we got the Juvenile Justice Act. Juvenile Justice Act was amended in 2015. What the law says is that a minor, if he is held guilty of a crime, the maximum punishment that can be awarded to a minor is 3 years. And that too 3 years in an observation home or a juvenile home. And once the child completes his or her term, after that, we have to destroy all the records. That is because to preserve the privacy of the minor, that the records they are not to be kept. Now, due to this, what happened, especially in our country, where it is not extremely difficult to manipulate birth records, there was an increasing number of minors who were being drawn into the net of crime. Sometimes they would be lured by money, sometimes the lure of an easy life, sometimes promise of a job, sometimes their own parents would push them into it because it was like, okay, maximum he'll go in for 3 years, after that he'll be back. And then definitely we'll be having money and all. Sometimes kids, they were being drawn into this because of the lure of drugs and all these things also. So what was realized that we needed to put a stop to this. So a new provision now this has been added, and it says that whoever hires, employs or engages a child to commit a crime, so mere act of hiring, employing or engaging is punishable with a minimum imprisonment of 3 years. And if the child further commits the crime that he was hired or employed to do, then the punishment that is prescribed for that crime, the punishment would be awarded to the one who had hired or engaged such child. So the child will be let off with 3 years, imprisonment of 3 years. But the one who has engaged the child would also, so it also uses the term also, which means is that minimum 3 years for the act of engaging, and additional punishment for whatever the child has done. So this is how we have tried to introduce new crimes. When we talk about organized crime, we talk about terrorist acts. Now organized crime, many states had their own organized crime statutes. But maximum number of organized crime, they are taking place from one state. You must have all heard about Jamtara. So Gujarat had an organized crime control act, Haryana had one, Rajasthan had one, West Bengal did not have one. So now, because there the maximum number of these organized criminals, these organized crime syndicates, they were operating from that area in the absence of an adequate law. We could not do anything about them. So now we have put organized crime in the central law. Okay, similarly, Terrorist Act. Although we had a UAPA, which is the Unlawful Activities Prevention Act, everybody says that it's an extremely draconian law. And yes, it is one because there is no provision for bail. Okay, and there is a detention up to 180 days that is mandated under that law. Now what have we done? We have also included Terrorist Act in the BNS, and now there is a discretion with a senior police officer, one of the rank of Superintendent of Police, to take a call whether the accused is to be booked after investigations under the draconian UAPA or under the BNS. In BNS, we have tried to dilute the law because bail would be available. The act of the accused would also be subjected to the general exceptions that are applicable in offences covered under BNS. General exceptions, they are available in cases of special offences or in cases of special statutes in a very truncated form. So now what have we done? It has been watered down slightly, and there is a discretion that is given to a very senior police officer. Discretion is to be exercised very cautiously. After conducting investigation, he will have a fair idea whether the person was a young person, whether there is a possibility of reform, even though he has engaged in a terrorist act, but was he indoctrinated by some gang? So is there a possibility of this child being brought back? Was he a victim of the circumstances? Was he pressurized? So in such cases, we can let him off with a lesser sentence under the BNS instead of putting him under the UAPA. So this is how, and there are many more new crimes that have been introduced. Obviously, we don't have the time to deal with all of those right now. So now what we have done, we have restructured and reorganized the old code systematically. In IPC, we had 23 chapters and 511 sections. Now when we talk about the chapterization, the first chapter deals with the preliminaries, then we come to the exceptions and definitions, explanations, and what we call as definitions and explanations. See, ordinarily when we talk about any statute, if we have to look for definition, we go to section 2. Section 2 is typically the definition clause in every statute. That is the standard practice that is followed. But in IPC, definitions and explanations, they were spread from section 6 to section 52A, and that too in a very unorganized manner, not even arranged alphabetically. Now what has been done? All the definitions, they have been compiled, put together in section 2. Then all the explanations, they have been put together in section 3. Then punishments, and then we come to a chapter which combines all the inchoate crimes together. See, what are inchoate crimes? They are incomplete crimes. In criminal law, even an attempt to commit a crime is a crime. Even abetting a crime is a crime. Even if you conspire to commit a crime, that is also a crime. Earlier in IPC, when the IPC was enacted, abetment was a crime, attempt was a crime, but these were all placed at a great distance from each other. And then criminal conspiracy was later on introduced as a kind of crime. Now what has been done? All these inchoate crimes, they have been clubbed and put together in one single chapter. Then what is the most interesting part is that in IPC what they had done, after the preliminaries, when we start with the specific chapters relating to crimes, the first chapter dealing with crimes, chapter 5, after the initial 4 preliminary chapters, was offences against state. Because at that time what was the most important for them was the state. But now what has been done after the preliminaries, the first chapter, chapter 5, deals with offences relating to woman and child. Now that was a chapter which was not there in the IPC. We did not have any such chapter earlier. Although we had provisions for protection of women and children, but they were scattered across the length and breadth of IPC. Now in chapter 5, all the offences relating to woman and child have been clubbed together. After that comes offences affecting human body, and only after that comes offences against state. So now offences against state is chapter 7, and offences affecting human body, which was earlier chapter 22, now that has been moved to chapter 6. Now this is just a matter of priorities. Does that mean the state is any less important now? The answer is no. The state is equally important, but what we need to understand is that no state can be more important than the people who comprise that state. And that is what is indicated by this new scheme of chapterization, wherein the most important is the most vulnerable part of our society, and that is women and children. And then coming to offences affecting human body, and then state, and then all other crimes, they have been included. Then defamation. See, defamation in most of the countries, defamation is a civil offence. In India, we retain defamation as a crime, but now we do not necessarily have to put a person behind bars in cases of defamation. He can be let off with a community service also. So community service has been introduced as a form of punishment in those cases also. So we've tried to remove certain archaic provisions also. Now we'll talk about the Bharatiya Nagarik Suraksha Sanhita. What is the objective behind overhaul of the law? To ensure for fast and efficient justice delivery, to release under trials on personal bond who have spent half of maximum prescribed sentences custody. So we all know it is so unfortunate that there are so many instances where the accused persons, they have been languishing in prisons even beyond the maximum sentence that they could have been imprisoned for. That is because although in bailable offences, bail is a matter of right, but what is required is that you are supposed to furnish bail. There has to be someone who stands as a guarantee for you. Now, see, there was a case, 1978, Moti Ram. That's a very interesting case. Now, what had happened in that? There was a migrant labourer who was working as a mason in a neighbouring state, and that person, he committed a very small crime. Now, the magistrate ordered him to furnish a surety of 10,000 rupees. In 1978, 10,000 was a very big amount. Now, where does this person get that kind of a money from? Moreover, the magistrate insisted that the one who stands guarantee for you must be from the same state. So, in that case, Justice Krishna Iyer had remarked that it is like a negation of his rights. It's a virtual denial of bail, because we all know that affluents do not befriend indigents. So how would such a person get anyone to stand guarantee for him, and where would he get that much of money from? So now what the law has done is, even on personal bond, because see, what can secure presence of an accused at the police station or during trial is if he knows that the long arm of law is eventually going to catch up with you, there is a proper policing in our state and you will not be able to evade it, it is only that can guarantee. Otherwise, it is even furnishing a huge amount is no guarantee. The person might jump bail. So acknowledging that, now a person can be released on personal bond terms. We've tried to reduce complexity by streamlining legal procedures. We have tried to reduce pendency by setting timelines for procedures in order to improve the rate of conviction. How rate of conviction can be improved? By leveraging technology. In order to establish the guilt of accused person, we can appropriately use technology in trials, inquiries and proceedings to be conducted electronically, also in absentia for proclaimed offenders evading trials. Why do trials continue for such long periods? Is because the vakil sahab will come in the court and he'll say कि आज मेरे मुवक्किल की तबीयत खराब है या आज गवाह नहीं आएंगे. Now what happens unnecessarily? We are seeking adjournments from the courts. Now it's okay. You can testify from the security of your homes also. Video conferencing is now permitted. Similarly, prisoner को लाने के लिए अगर कोर्ट में पेश करने के लिए we don't have adequate personnel, so he can also testify from the prison itself. Then coming to proclaimed offenders, we've got so many people who flee the country. We keep waiting for them. कि कब उन्हें हम पकड़ के लाएंगे and only then we can put them up on trial. Now what the law says that there is a procedure prescribed. Once they are declared as a proclaimed offender, we issue a notification and after waiting for some time, then we initiate trial. Why we would not initiate in absentia trials is because that is a violation of the natural principles of justice. Because we go by hear the other side. So if a person is not present before us, we don't hear that person's version. So we feel that somehow justice is being compromised. Now what the law says is, see, we have given you an adequate opportunity to make an appearance before the court. You are not coming. Now we will hold an absentia trial and you may choose to be absent from the trial, but you do so at your own peril. And we will continue with the trial and will also pass the sentence. But now the problem arises how we will execute the punishment, because the accused is not with us. So although we have now introduced provisions in the BNSS where we can issue a formal request to the other country to help us in investigation, to help us in bringing back that person home, but all that would depend upon the extradition treaties and all that we have with those countries. So we'll have to see how it actually plays out once the law is implemented. Then utilization of forensics have been mandated for offences punishable with imprisonment of 7 years or more. See, offences that are punishable with imprisonment up to 7 years or more, these are more serious offences. So in such cases, we have to ensure that the innocent does not get unnecessarily punished and the guilty does not escape punishment. So that is why what we have mandated is usage of forensics now. From Indian Evidence Act to Bharatiya Sakshya Adhiniyam. The existing law does not address the technological advancements and therefore we need a law to fulfill the contemporary needs and aspirations of our people. Evidence includes any information given electronically which would permit appearance of witness, accused, experts and victims through electronic means. Electronic or digital records would be admissible as evidence having the same legal effect, validity and enforceability as any other document. See, in the information age, can we still keep on insisting upon paper documents? We cannot do that. We got the Information Technology Act in the year 2000. The same year we tried to amend the Evidence Act. We amended it again in 2008. But now what we've done is there has been a substantial amendment and now we have clearly provided that documents would include electronic records, digital records and all these kind of records and all these kind of documents which are required to establish the guilt or innocence of an accused before the courts. Then it also expands the scope of secondary evidence to include copies made from original by mechanical process. It puts limit on facts which are admissible and its certification as such in the courts, and it introduces more precise and uniform rules of practice of courts in dealing with facts and circumstances of case by means of evidence. So now what is the paradigm shift? Instead of focusing only on punishment, the focus is on providing justice to all stakeholders. We have introduced concept of restorative justice while retaining deterrence element. See, many times people say that while worldwide there is a moratorium against death penalty, why have we still retained the death penalty? Because on one hand we go by the reformative approach towards justice, but still we have retained the deterrence element. See, death penalty is prescribed in many number of offences, but then we don't have a mandatory death penalty in our law. The Britishers had introduced mandatory death penalty in cases where one who was already convicted of murdering a person, in case he again killed someone while in prison. So in such cases, there was a mandatory death penalty. Our Supreme Court in Mittu versus State of Punjab, that's a 1996 judgment, it had removed that statute, that provision. Now we have reintroduced it, but in an amended form. We don't have mandatory death penalty anymore. Death penalty, and also there is an option for life imprisonment in such cases. So there is a discretion with the courts. Then death penalty, although we have retained it, but just because the law provides for death penalty doesn't mean that death penalty is to be awarded in every case where there is a provision for the same. We have a qualification for that, and that is death penalty is to be awarded only in rarest of rare cases. And who decides whether a case falls in this rarest of rare category? It is the court. For that, they have an inventory of aggravating and mitigating circumstances. We apply both the crime test as well as the criminal test in deciding whether actually the crime was committed with utmost barbarity, in an extreme gruesome and cruel manner so as to merit the extreme penalty of law or not. It is only in those cases that death penalty is to be provided. So we had to retain the deterrence element, but by and large we have also the reformative approach as the basis, and now we have also introduced restorative justice in the form of community service. Then a better structuring of the law in a more systematic manner, which makes it easier for people to understand, because at the end of the day, laws are meant for the people. It is not to be read only by the lawyers or the judges or the legal academies. It is meant for everyone. So it should be in a language which can be understood by those for whom it is meant. So all definitions, they have been updated. Some acts have been decriminalized, enhanced punishments have been provided for others, redundant provisions have been deleted, usage of technology in forensics and crime investigations, fast tracking of cases. In petty offences, summary trials made mandatory. The victim has more say. See, now victims, they have to be supplied copies of first information reports, and they have to be kept updated about progress of investigation. And in cases where punishment is 7 years or more, victim has to be heard before the state decides to withdraw prosecution. So now victim has some say in the system. Now we have also introduced witness protection scheme in the statute. We'll just leave it. This is just a broad outline. Some revised definitions. India. IPC defined India as the entire territory of India except the state of Jammu and Kashmir. Now we don't need a definition of India. After the application of Article 370, we know India is across the territory of India. There is no exclusion as it is. Child we have discussed, document we know, electronic and digital records. The pronoun, it is now inclusive of this, transgenders also. Now the British calendar, the term British calendar, it has been replaced with Gregorian calendar. Not that it has any great significance, because both the calendars are the same. After every 4 years we introduce one day, because ordinarily a year consists of 365 and 1/4 day. After every 4 years we introduce one day, more day, and that is what is known as the leap year. But we have changed the name. Why? Because this was an attempt at decolonization. Why should we retain terms such as British calendar, British Queen, Crown? We don't need all that. So we have replaced it with a more universally accepted term, which is the Gregorian calendar. Then movable property again. Then references to juryman omitted from definition of public servant. See, we don't have the jury system anymore. Jury system, which was discontinued by us mainly after the KM Nanavati case. You must have heard about that case. There was a movie also made on that. That was Rustam movie. You remember the case of an upright, honest naval officer. He was a Parsi naval officer, and his British wife had cheated on him while he had gone abroad on some assignment. So the wife, she had some relations with his friend, and when the man, he came back, he saw that his wife was distant and aloof, and when he asked her, she said that she wanted to marry that man. She wanted to divorce her husband and she wanted to marry that man, but she was not sure whether the man would marry him. So Nanavati had also stated that, see, at that moment I wanted to kill myself, But still what he did, he took his wife and children to a cinema hall because he had promised to take them to a movie. Then he went to his ship, he took out a revolver, he took 6 cartridges on the pretext of traveling out at night. He went to that person's house, he called him out when he was not there, he straight away went into the bedroom there was a scuffle between them and he shot him dead. Everybody knew this was a case of murder. But when the case came up for trial, because there was a leading newspaper at that time which was run by another Parsi person, so the entire media was in favor of Nanavati because everybody felt that an honest and upright naval officer had been wronged by his British wife. So the media, it influenced the jury opinion considerably and the jury pronounced a verdict of not guilty. They said he had not committed murder. He was provoked by that man and that is why he did so. But this was overturned by the High Court and that was the case which highlighted that jury is impressionable. Jury can be influenced by media and by public opinion. So after that, we just started cutting down on jury trials and eventually we abolished it. But till date in our law, we had the term juryman, although we did not have a jury. So that term, it had to be removed. Now, we don't have jury people, so jury people are no longer any public servants. Court of Justice, it has been replaced with court. Now, before you draw any conclusions, here the definition is like a court is a place where a person is acting in a judicial capacity. So, one who is acting in an administrative capacity will no longer be known as a court. Then there are certain new kinds of crimes that have been introduced herein. Okay. These are all, I don't think we have so much of time for all this. Maybe we can take some questions now, because I'm sure you must be wanting to ask questions about sedition or causing death by negligence. There is one single provision that has been put on hold as of now. So I think we'll now open the floor to questions. So this is also some of the provisions that have been repealed. In this, before I conclude, I would like to shed some light on one provision that has been repealed, and that is relating to criminalization of adultery. Did you read the judgment which had decriminalized adultery? That is Joseph Shine versus Union of India. That was section 497 in the Indian Penal Code. What did the provision say? The provision said, if a woman has sex with a man other than her husband, except with the consent or connivance of her husband, then the husband could prosecute the other man as an adulterer. The husband could not prosecute his own wife, not even as an abettor. The wife was not to be held guilty because as per the law, women don't have a mind of their own. They can be easily led or swayed away. So that is what the law was. Moreover, see, what about that man who is the adulterer? Maybe he is also married. So his wife, she could not prosecute either her husband or the other woman. So it was held that this was a provision which was very patriarchal in nature, because what it reinforced was that the husband had an absolute monopoly over his wife's sexuality, whereas the wife could not claim such a monopoly over her husband's sexuality. So that was, and moreover it was so discriminatory against the woman as well as the man in certain cases. So that is why it was struck down. So although it was struck down, but lawmaking is a legislative function. So the provision, it continued to exist in the IPC. So now what we've done, we've weeded out that provision. And see, Britishers, they introduced this provision in our law, but they themselves removed this provision way back. Similarly, when it comes to marital rape, again, something which reinforces the patriarchal notion of the husband being the master of his wife. Now again, marital rape, we have exempted marital rape. It's not a crime if the wife is above 18 years of age. That also we've made now. As per the IPC, when the Britishers enacted the law, at that time the age of consent for a married woman was 10 years. It was only when a 10-year and 7-month-old girl, she succumbed to the injuries when the husband tried to establish marital relations with her, that it was realized that no, 10 is too tender in age. At that time it was raised to 12 years. After independence we raised it to 14 years, then it was raised to 15. And that what happened, that there was a window. If the wife is between 12 to 15 years of age, the husband would be punished up to 2 years, and the husband would not be punished if the wife is above 15. Punishment would be only in cases where the wife is below 12 years of age. So now what has been done, it has been raised to a uniform 18, the law. So these are some of the main changes. Now I open the floor to questions.
where that young boy in Pune, he killed two people with his Porsche. So I read this news somewhere on the internet that the court has said that putting him in detention is causing trauma to that boy. The family of the victims are all they are traumatized,
They're
obviously,
also traumatized.
but the boy who has been put in detention is also traumatized. So that is unlawful. The court has said that. So what do you say about that?
See, courts, they are just interpreting the law. And that is what the Juvenile Justice Act said. Moreover, people were like, the juvenile was let off after writing an essay. No, no, writing an essay was just a condition for his release on bail. And now what happened is bail was also cancelled, and now what the courts have done, they have just released him on bail. Although his parents, the doctor and the local MLA and all, they are still behind the bars. But see, when children do such acts, it is not that they have deliberately done it. We all know that children, they are more impulsive. Below 18, they don't have that much of control over themselves. And it is for us to guide them. So when a child commits a crime, it is in a way a collective failure of the society. So you cannot criminalize our children. What they need is a better guidance. Unless, of course, it's a heinous crime that has been committed by the child. Then in such cases, if the child is between 16 to 18 years of age, then the Juvenile Justice Board takes a call whether the child is to be tried as a minor under JJ Act or as an adult under the IPC.
Thank you. Another question, ma'am. Since we are now submitting digital records, we are seeing that AI has taken a lot of space here, and easily things can be faked. So how will we employ are there employment of softwares that detect that fake?
So we are trying to do that. That is why we have mandated usage of forensics. We have to up our game. We have to beat the criminals at their game. Trainings and all, they are going on. Let us see how it works out.
Thank you for extremely informative session and you have, ma'am, talked in such a comprehensible manner that even anybody in this room can understand what you have spoken. My concern here has been that since it talks about decolonization, it talks of matching the needs of contemporary Indian society, is it going to influence the vast distance between global north and global south? For example, when we talk about parents, NRI parents or overseas families, where socialization for Indian families is different and the children are sent to foster care. There was a Norwegian case also, which was there. And what will be the effect on inter-country adoption or laws where other countries are also understanding this, what India is? Thank you, ma'am.
Ma'am, adoption is a matter of personal law, and for that we already have secular CARA guidelines. So IPC as it is not going to have any impact on that. When you talk about foster and all, foster care is basically an Indian concept. हमारे यहाँ कृष्ण जी को किसने पाला था? यशोदा ने. उनकी foster mother ही थी. अंग्रेजों की या वेस्ट की आदत रही है वो हमारी चीजें लेके हमें ही सेल करते हैं, जैसे हल्दी. They were just trying to patent it and all that. So that has been happening. We need to be proud of our own heritage. हमारा अपना knowledge system इतना advanced, इतना developed है, and why should we try to come up to the level of them? Let them try and come up to our level, because what I feel is we are already at a much higher level. And this criminal law, there will not be any kind of a division. See, for that matter, even if we enact a UCC, that is not to be seen in a negative light. Because this is our country, our people, and we have to take care what is best suited to their interests. And it doesn't mean just because we have removed some of the old archaic terms, why should we be worried that they'll see it in a negative light? It was high time we did it for ourselves, for our own dignity.
Also, ma'am, I have a very question which was mentioned.
Keep it close.
Ma'am, I have a question. Ma'am, few days back there was an article in the Hindu. So, ma'am, it was mentioning about a person who was a college student, and he was raped by his hosteliers, and so he committed suicide in such a terms, and It was the article was referring about the Singh Johar versus Union of India case 2017, where the Supreme Court have decriminalized.
Decriminalized consensual homosexuality.
Yes, ma'am.
377.
Yes, ma'am. And after that, it was also mentioning that cows, the rape against.
Bestiality was also a crime in IPC. It is no longer so in BNS.
So, ma'am, is ma'am such a law required in BNS, ma'am? Because ma'am, opposition parties are also seeking that the BNS is not having such a law and how it would impact our society.
Okay, I'll tell you the non-inclusion of 377. It's a very contentious provision. Because see, under BNS, what was criminalized was homosexuality, whether it was consensual or homosexual or non-consensual. In Navtej Singh Johar case, what the court did, it watered down the provision and consensual homosexuality was taken out, and what was held was that when two consenting adults want to be together, there is no problem. The law has to intervene only when either there is a lack of consent or there is a minor involved. Okay. So now when we talk about homosexuality, so for minors we already have POXO. So under POXO minors are protected. Women, they are protected under rape laws because the definition of rape, it has been significantly broadened, and all sorts of penetrative violations of a female anatomy, they are covered here. So now who is left out is only an adult man who is not protected under this. But then we have provision regarding sexual harassment of a man by another man, which is a punishable offence. We have punishment for usage of criminal force. We have punishment for what we call as grievous hurt. So all those provisions, they can be invoked to protect men against this kind of a penetrative sexual assault. So that can be used there. Then coming to bestiality, definitely that has been an omission somehow I feel, because if we have to rely totally on the Protection of Animals Against Cruelty Act, there are very little slight punishments that have been prescribed which would not have any kind of a deterrent effect. So now what would be next would be amending the Animals Act. Do we have any other question?
Ma'am, any particular reason why marital rape has not been criminalized?
Again, although that is not something which I totally believe in, but the reasons that have been given are that, see, sexual violence is already acknowledged as a kind of violence under the Domestic Violence Act. Okay, then what they are saying is under cruelty. Physical cruelty is acknowledged as a cruelty. Then it is a ground of divorce on the basis of which cruelty, on the basis of which a woman, she can seek divorce. Under DV Act, she can seek separate residence, she can seek restraining orders from the court. So what they are saying is that as it is, we've got sufficient provisions to deal with that kind of a crime, and because we don't have proper procedures and rules of evidence in place, how we could establish it. So there is a possibility that if we criminalize marital rape, this could be abused. Okay, so that is why till we don't have a proper mechanism in place how to actually establish whether rape has taken place within a marriage or not, till that time we have put it on hold. But I don't think just because it is difficult to prove a crime, so we should allow it to continue as a crime.
Mark, thanks so much for such a enlightening talk. I just have a very brief question. Do you still think that, UAP and DNSS, they sort of overlap when it comes to terrorism?
So I told you, there's a difference there.
Yeah, but terrorism is still considered under the chapter of offense against the body and not against the state. So could you just
Yes, because actually who are the victims of terrorism? People, and that is why it is put in offences against state, not offences against human body, not in offences against state. That is it. So nobody wants to ask any question regarding the one provision that has been put on hold, section 106, causing death by negligence. Hit and run cases there. Because see, all the three laws, they will come into force from 1st of July, except one single provision, that is subsection 2 of section 106, which is causing death by negligence. See, as per the NCRB data, the number of lives that are lost annually in hit and run accident cases are even more than the number of lives that we lose annually in murders, in cases of murders. See, so what this provision has done, hitherto what was just a moral obligation, now it has been made a legal obligation. That after accident, you are supposed to inform the police or the magistrate so that within the golden hour, help can reach the person, the injured person and casualties can be minimized. But then there was a lot of protest over this by the truck drivers and all, because they said that we drive under very difficult conditions and we drive for long periods of time. And sometimes if there is an accident and if we were to stop there to help the injured person, a mob would collect there, our vehicles would be damaged, even we could be subjected to mob lynchings. So they said that maybe this needs to be put on hold. See, what they do not know is the day when this law will come into force, the same day BNSS will also become operational. And now BNSS has got provisions as to zero FIR and EFIR. FIR रजिस्टर कराने जाते हैं तो jurisdiction का बहुत important होता है. आप कहीं जा रहे हैं, रास्ते में क्राइम हो गया, आप क्या करेंगे? आप इंतजार करेंगे, पहले आप घर जाएंगे, फिर आप नजदीक के थाने में जाके FIR रजिस्टर कराएंगे. But the police officer will say that no, this is not our jurisdiction, we go to the proper jurisdiction. So now what the law says is you can approach any police station, the police officer cannot refuse to register an FIR. You do not know what the appropriate jurisdiction is, but the police officer knows. So what he will do, he will enter the information in a register meant for that purpose, but he will not give a number to that FIR. And that is why it will be known as a zero FIR. And now it is the responsibility of the police officer to transfer it to the proper jurisdiction. So one thing would be zero FIR, another would be EFIR. You don't know how to go and register an FIR, you are not in a position, you can just make a call. Register the FIR. You can log into the website and you can register the FIR. In case some immediate action is to be taken, suppose medical help is required, the police will immediately spring into action. Otherwise, they will wait for 3 days for you to physically go and sign at any nearest police station that EFIR and only investigation commence. But truck drivers and all, they were not aware of this. Moreover, how many of our drivers would be so tech savvy as to access these smartphones and also be able to log in and register their EFIRs? So in addition to this, these were not the only reasons why this section was put on hold. The other important reason was that this section, it appears to be in conflict with our Constitution Article 20, which talks about rule against self-incrimination. How can you ask a person to give information of a crime that he has committed? Would that not amount to a kind of an admission of his guilt? So now all this had to be all these concerns had to be addressed. So what we have done, we have put the implementation of this single provision on hold. Otherwise, all other provisions will be coming to force from 1st of July.
One last question. So, ma'am, you are also working with the Department of Legal Affairs, Ministry of Law and Justice. And while awareness campaigns which aim to societal engagement are a similar right direction, so various government personnel and stakeholders involved would also need some sort of reskilling and upgradation with the new laws. So, ma'am, in order to plug potential implementation failures, what are the different ways of the approach?
So already a scheme in place, a plan, a map has been charted, and trainings they are being conducted for police officers and all other personnel. But the large number of personnel that we have, the trainings will take some time. Although these trainings they are going on, but it is going to still take some time. As of now, the ministry is holding these awareness programs in all the major metropolitan cities. We've already done it in Delhi, Guwahati, Calcutta, Chennai. This Sunday it is in Mumbai, and there we call all the judges of that particular area, the Solicitor Generals, most of the public prosecutors and all, law students, teachers, they are all called there. And then there's an awareness session, a day-long awareness session in which they are actually told about what the law is. And there are also training of trainers programs going on in all the states, where trainers, they are being trained, who will further train the other prosecutors, police officers and all.
And do we we also have paraphernalia for the
Sadly, not as of date. We need to also work on the infrastructure. Any more questions? So I think that will be all. Thank you for a very patient hearing. Thank you.
Thank you, ma'am, for a very enlightening session. Dean of Colleges, Professor Dr. Balram Pani, still stuck in traffic. His extensive apologies. I now request IQAC Coordinator Dr. Vinita Dini to please give the vote of thanks and convene the session. Commence with the ending of the session. My apologies.
Thank you, Anushruti. Ladies and gentlemen, it is my great honor to extend a vote of thanks on behalf of everyone present here today. As we conclude this enlightening seminar, I want to express my heartfelt gratitude to everyone who made today's event a resounding success. I warmly thank our distinguished speaker, Professor Vageshwari Deswal, for sharing her expertise and shedding light on such a relevant and critical topic. Her thorough analysis and clear explanations have significantly enhanced our understanding of the new legal landscape. The recent changes in criminal law are bound to impact many facets of our society, and your ability to break down these changes into understandable terms is truly commendable, ma'am. You have not only informed us about the legislative updates, but also provided practical insights into their implications and applications. I also warmly thank the principal of our college, Professor Gyantosh Kumar Shah, for his guidance, his support. His vision for our college is truly remarkable, and his vision also inspires us every day. I would also like to thank our attentive audience. Your active participation and thought-provoking questions have added immense value to today's discussions, and your enthusiasm has been instrumental in making this event meaningful. Through such informative sessions that we can stay informed and adapt to legal changes effectively. I also want to thank everyone who helped organize this event, ensuring everything ran smoothly and efficiently. Your hard work behind the scenes is much appreciated. In conclusion, let us all take the knowledge and insights gained today and apply them in our respective fields to better serve and support our community. Once again, thank you all for your invaluable contribution and for making this session a remarkable success. Thank you all. Let us all rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We've also arranged for refreshments for all the attendees and participants. As you step outside the seminar hall, please.
For faculty, the refreshment is just outside the